Hi, I am Lamborghini_C, also known as the HR Whisperer, and welcome back to my channel. So I'm going to talk about a hot topic. So a couple weeks ago, I actually had a mini viral moment, actually more viral on IG than on TikTok. But I did a post in communication about the new DOJ ruling banning non-compete agreements. And that caught a lot of people's attention. There was a lot of interest in that topic. So I'm coming here just to discuss it a little bit more in detail. So by now you've heard the news that the FTC just made a huge decision and issued a final ruling banning the use of non-compete agreements. So what does that mean for you or for your business? So employers need to notify those individuals that are on non-compete agreements that they no longer can enforce those non-compete agreements. Now, here's a couple of things, and this is why you need to read the ruling and make sure you understand it for yourself, or check with your trusted HR business partner, or call the HR Whisperer. But it does not apply to some senior executives. So again, some of those folks that operate in that level, you still are subject to a non-compete agreement. In lieu of a non-compete agreement, one of the things that companies can begin to do is utilize NDAs. And so again, if you are a company that has some concerns and you were using those non-compete agreements as a protection for your organization, again, you're going to want to contact your employment attorney and your trusted HR business partner, the HR Whisperer, to get guidance on issuing those NDAs in lieu of the non-compete agreements. But go check it out for yourself. The ruling is issued. It's out there online. Everyone's talking about it. But the HR Whisperer wanted to make sure you're informed. Have a great day. Bye. But guys, this is like huge. This for every industry. If you've worked for corporate America, this is really a huge decision. Now, I have to tell you a couple of things. First of all, for some executives, the non-compete agreements are still going to be in effect, right? The main thing too that I want to get out there is that, again, this ruling doesn't actually go into effect until 120 days after the rule has been filed, right? The ruling. And then we know that there's going to be companies and other individuals that are going to oppose the ruling. So expect lots of litigation to come out of this. So again, while it's a win for, a lot of employees see it as a win for themselves, again, kind of just, wait and let's see what happens with it. Now, I do have to tell you, oh my goodness, it was a lot of information to comb through. It's about 570 pages, I believe, for the actual ruling, to kind of get through it and everything. And so I think that, if you think it's going to impact you, if you are a business owner, you're going to want to read through that yourself, or more importantly, get with a professional like an HR, consultant like myself, the HR Whisperer, or an employment attorney, so that they can walk you through that, and then maybe even help you line up strategies on how to kind of get around that, right? To make sure that it doesn't negatively impact your business. I'm definitely consulting with my clients on ways that we can, implement other things that actually might even be a better or more appropriate solution to what it is that they were trying to do. The reality is that in some cases, the non-compete agreement, it really, it was there, right? And I think they had some assurances, but it might not have even have been the appropriate tool to really, keep intact what they were trying to keep intact, right? And so a lot of times folks are really, concerned about if they have special, like a restaurant, business, special ingredients being shared, with a competitor, or intellectual property being, shared when an employee leaves. And so really, I argue whether or not the non-compete agreement really was the best solution in that case or not. So I think, again, I'm happy for employees that have felt as though they've been disadvantaged by having the non-compete agreements that they've had to, live by. I've definitely, had situations where I've had, non-disclosures intact, or, non-compete, for a certain period of time, especially again, as you, work your way up through those executive ranks in companies. A lot of times that comes with, the territory, right? Because you are privy to a lot more data and information. You're privy to the numbers. And so again, the companies have to protect themselves. But let's talk more about like small businesses and, from the vantage point of even corporate small businesses, which again, a corporate small business can still be, several millions of dollars, right? They can still be, 20 or 30 million in revenue annually. But they might be a startup, right? And they might have, some cutting edge technology. And again, that's where I question, like, again, is non-compete even the way to go? Again, they might really want to even consider the non-disclosure agreements. Like I said, that probably was even the more appropriate, solution as opposed to the non-compete agreements. But I say, again, if you are a small company or business in general, don't fret too much, right? Over this change, because I think working with a professional, in the field, either HR or employment law attorney, we will be able to guide you along some solutions that, will be the best fit for your organization and making sure that you're able to keep things safe, right? And just tighten and buttoned up. But, for the employees, like I said, I'm happy for you. I know for certain industries, the insurance industry, which I am a part of as well, the non-compete agreements actually was a hindrance in being able to, sometimes, go to another IMO and, work there and what have you. It held a lot of people back. And so I know they're really excited about it. Yes, under this new ruling, the insurance companies are subject to it as well. So in answer to this question, the answer is yes. So actually, the commission declines to adopt an exclusion for client or sales-based industries such as real estate and insurance. So yes, the insurance agents are impacted by this decision, which means, again, non-compete agreements do not stand within these industries. And so, of course, that there's people in the industry and the IMOs that are not happy about this. They got busy writing in and trying to argue their case, but yet and still, the commission still chose not to adopt an exclusion for either the real estate or insurance industries. So keep the questions going. I got you because I had to comb through 570 pages of this ruling, but keep the questions going. Now, there's a lot of pushback from the IMOs. And so, again, I completely expect there's going to be the lawsuit filings that take place. And, I think, they already have gone on record to discuss how they see this as being a hindrance to the industry itself. So, again, this has been a hot topic. It got a lot of people, kind of anxious and, whether excited or whether, if they were on the other side of the coin, kind of upset. So there's a lot of information out there, guys, and I'm going to share with you where you can go so that you can actually get some additional information on this and go, like I said, and seek the information for yourself. So let's just take a look. Right. So here we have, a lot of news. So if you just type in simply DOJ non-compete, you're going to see several articles. The FTC votes to issue the final rule banning most non-compete agreements. And again, that's key language. Most is banning most non-compete agreements nationwide. So again, we want to look through this and make sure that we have the most up-to-date and appropriate information. Now, if you want the actual agreement itself, you're going to want to go to www.justice.gov and you'll be able to search for it there. I'm just going to go into the document. Like I mentioned, it has quite a bit of information here. Now this is 7 pages worth. There's another more in-depth document that I have saved that I've gone through that also includes all of the different arguments from the from the various industries, right? Because they got wind that this ruling was going to go into effect. And like I said, that document is about 570 pages. And that's where I had to dig a little bit deeper to understand whether or not this actually applied to those in the insurance industry. Again, mind that, I do have a vested interest, in that as well, for myself personally, as well as acquaintances and friends that are in the industry. But you are going to want to take a look at this, guys. But like I said, this is Huge, huge, huge news. So you don't want to miss out. Again, this is just another tip, another update from the HR Whisperer. I will keep these coming because we want to make sure that you're informed as best as possible, whether you yourself are an employee or if you're an employer. And if you are struggling with what to do, if you have employee issues and you're just not sure if you're handling them right, I encourage you to reach out to us at edmund-enterprises.com and schedule your free consultation with the HR Whisperer. Have a good day. Bye.